Welcome to a question and answer session on Part Code Matters, Disputes and Resolution by Ibrahim Dolmir, barrister at parkhomeslaw.com. This session was recorded in October 2023. Any guidance provided in this session today should not be treated as specific legal advice, nor can it be treated as definitive advice, simply because I do not know the full facts and circumstances for each and every question. Therefore, if you're uncertain of your legal position as a listener today, then you may wish to contact me to provide you some clarity and some direction on your particular circumstances. The questions today have been provided by members of the Residential Park Homes for Nice People Facebook forum. So these are real-life questions. Of course, however, the questions have been anonymised and simplified. Let's start with question 1. We have a defective exterior on our park home. Can you help? Well, my understanding from this question is that the exterior defects would probably include blistering, cracking, and damage to the exterior boards of your park home. Now, I understand that this is a nationwide issue that permeates the sector. There are short-term and long-term impacts in my view. Obviously, the short-term being your inability to enjoy your mobile home in this moment in time, whereas the long-term would be looking to see the value of the mobile home as a consequence, and also the saleability as a result. Which really brings me to the next point of how important specific legal advice is in these circumstances. However, for the purpose of this presentation, I shall be providing 2 points to take away here. The 2 points are that there is a direct application on the Consumer Rights Act 2015. And furthermore, the listener, if applicable of course, has to bear in mind that there is the Limitation Act to be aware of. And what I mean by that is there is a 6-year limitation on contractual disputes. On to question 2. If a site owner makes a verbal and documented commitment during a tribunal hearing, i.e. to replace something, what can we do if that isn't done? My view is you start off by looking at the tribunal determination very carefully. The orders would usually be at the end of the determination, and it would outline what the tribunal had ordered. In other words, what the site owner has to do. I would then recommend that you outline your understanding of that determination to the tribunal, and if, for example, it makes it very clear that X has to be replaced within the determination, then you would be outlining that to the site owner. If that doesn't work, you can obtain some specific advice and remit the matter back to the tribunal. Question 3. We have flooding around our park home due to inadequate drainage. What can we do? My view is, with any dispute that you have, it's a good idea to highlight your concerns to the site owner first. Give them the opportunity to put forward their response before you escalate matters. If the site owner has a complaints process, you may wish to ask them for their written complaints process and follow this. If that doesn't bear any fruits, the next stage would be to look at the site license conditions and any reference to the drainage. If the site license, in your view, is being breached, then you would provide the local authority with evidence of these potential breaches. The local authority would often investigate these breaches and hopefully help the parties resolve them. If, for instance, resolution is not met, it is understood that the local authority can issue a site license compliance notice to the site owner. If the above doesn't work, then of course you should be obtaining legal advice. Question 4. If there's an outstanding balance owed on the park home I live in, can I be forced off the site? Before I answer or give any guidance on this potential conundrum, I'd suggest that the listener take this as an example as to why park home legal advice is essential before you proceed. So therefore, before you hand any money over, it is imperative that you understand your legal position. So for instance, where there are occasions where there's an arrangement between the site owner for you to pay the balance at a later date, that really ought to be outlined in writing and agreed. So therefore, this goes back to ensuring that due diligence is provided by your legal advisor and clarity is provided on your legal position, i.e., if you owe any outstanding balance and when that balance should be paid by, and what the potential ramifications of failing to pay. There is an enforcement notice on our plot. What can we do? My mother is 88 and is distraught. Again, this is an example of why legal advice is so important before buying a park home. You want to understand the ins and outs of your potential purchase before handing money over. And your legal advisor would be doing the due diligence on the paperwork and covering aspects such as any potential enforcement notices. It is also important that you obtain advice on the potential mis-selling of your park home purchase and misrepresentation or breach of contract. Now, if there is an enforcement notice that has come about as a consequence of your own actions, then you may wish to get specific advice as soon as possible on that. Question 6. I live on a residential site. I've been concerned recently at the amount of housing development in the area. What amount of compensation would I expect to receive? Now, for compensation, there ought to be some sort of claim at hand. It's not clear or apparent as to why you claim that there is a compensation claim here. It might be that you're inferring that representations have been made that the housing would not be developed to such an extent before you entered into contract. It would be worthwhile looking through the representations made in writing, whether you recall any conversations made by the site owner. It's worthwhile that you put your concerns in writing to the site owner and ask them for their comments before deciding whether you should obtain specific legal advice. Question 7. Why does it take so long for the FTT panel to make their decision? Well, firstly, the FTT is an acronym for First Tier Tribunal, and that's where disputes are often heard when it comes to park home matters. The tribunal is extremely busy in my experience, simply due to the sheer number of applications that it's dealing with. This is another reason, in my view, why parties should try to address their concerns and resolve them. between themselves before escalating it to a tribunal. But in terms of practical advice here, when there's a delay, I would always suggest that you email the case officer in question for an update. And in my experience, you'd always find that the case officer comes back. Question 8. What happens if we decline to pay the pitch fee increase? Well, there's two ways that the pitch fee can be increased, and that is by agreement between yourself and the site owner by paying the increase, or by determination of a tribunal. Now, if you decide to decline to pay the pitch fee increase, practically you may wish to have valid grounds before you do that. Otherwise, you'd be facing a tribunal application from the site owner. However, it's really important by paying the previous pitch fee level, you would not be in breach of your agreement. Question 9. Can I add a fence or a gate to secure the land around my park home to keep my dog in? Firstly, you really ought to check the written terms of your written statement under the Mobile Homes Act 1983. It would usually outline what you can and what you can't do within the written statement express terms. Generally, in my experience, you'd have to ask permission for any such works to be undertaken on your pitch. And generally, the site owner would be unable to withhold consent unreasonably. However, you might want to look at the site rules also. 10. Can I add a conservatory or porch to my mobile home or park home? Generally, a mobile home would need to be mobile. In other words, it cannot be affixed to the land. However, this can be a thorny issue, so I am unable to provide you with a view without the full facts and circumstances. But I would refer you to the last slide, in that before you undertake any type of works, you really ought to pass this by the site owner and obtain express consent if it is permissible. Question 11. Who do we appeal to if a resident is being bullied by the site owner? Although this is a very sensitive issue, my view is that it's always best to be transparent with the site owner, perhaps by putting your concerns in writing regarding the potential or the alleged bullying. If that doesn't work, then of course it might be an idea to highlight this to the local authority. The local authority have powers to intervene when there is bullying, harassment, and/or intimidation. You may wish to put your concerns in writing to the Environmental Health Department or the Licensing Department for assistance. I would always urge that when contacting the local authority that you make your complaint as succinct as possible. On to our final question. Question 12. What is the position when a park owner or site owner is not passing on the government's discount on electricity to residents? Well, I can't give you my opinion as this relates to government policy, but what I can say is that there was recently a call for evidence that ended on the 18th of September 2023. In my experience, the government stance will then follow. Thank you for taking the time and effort to listen to this presentation today. Should you have any matters that you'd like to discuss, whether included within this presentation or otherwise, then please do not hesitate to contact me using parkhomelaw.com or my email info@ibrahimdolmayer.com. Thank you again and all the best.